Hi, I'm Alan Bacon. I'm head of BTMK Personal Injury Clinical Negligence Department at Southend-on-Sea. I've been a solicitor since 1982 and I head up a team dealing exclusively with claimant personal injury and clinical negligence claims. At BTMK Injury, we've specialised in claimant personal injury work for over 25 years, and in that time we've assisted hundreds of claimants recover their rightful compensation, whether their claims arose from accidents on the road, in the workplace, through tripping and slipping, through clinical negligence or otherwise. We're here to help. Most people when they come to see us are worried about cost. You needn't be. We don't charge for the first interview or for the assessment of your case, nor do we charge if your claim fails. You will also receive 100% of your compensation if the claim is successful, because the defendant will pay your costs. What does a personal injury claim involve? If you instruct us, we will submit a letter of claim to your opponent, normally called the defendant, and the defendant will have approximately 4 months in which to provide a detailed response to that letter of claim. And during that time, we will be obtaining medical evidence as to the injuries which you suffered. Our emphasis is very much on your rehabilitation, your recovery, and an early settlement of your claim without recourse to the courts. If you've got a claim, what can you claim for? You can claim for the injuries which you've suffered. You can claim your past losses, for example, loss of earnings, medical expenses, treatment costs, prescription charges, and so on. If you've spent £1, you're entitled to £1 in compensation. Also, if you're going to incur losses in the future, you're entitled to claim those losses as part of your claim. So how do we approach and assess these claims? So far as your injury is concerned, we have access to a large database of medical experts, and the appropriate expert will be instructed in your case to prepare a report as to the injuries which you've suffered. We will recommend that your claim should not be settled until the medical prognosis is certain, because until then there is a serious risk of undercompensation. We will guide you through the whole process. Statistically, the chances of a case going to trial are low, but we will take it to trial if necessary. How long will your claim take? This depends on the medical evidence. We will not recommend a settlement until such time as the medical prognosis is clear, but we will move the case on as quickly as we can to achieve the payment of maximum compensation to you. How long do you have to pursue your claim? Generally speaking, the rule is that you have 3 years from the date of the accident to issue court proceedings. This doesn't apply, however, if you're under 18 years of age at the time of the accident, in which event you do have until your 21st birthday to pursue the claim. How much compensation will you receive? This very much depends upon the extent of your injury. If you suffer a relatively minor soft tissue whiplash injury as a consequence, say, of a road accident, with a recovery within about 6 months, you may receive damages of about £1,500 to £2,000. However, if you suffer an injury of the utmost severity, it may be several years before the compensation is payable and until the medical prognosis is known. In that event, damages will be very substantial. One of the most frequently asked questions in relation to workplace accidents is whether the claim can be pursued against an employer for whom you're still working. The answer is yes. Employers by law must hold employers' liability insurance, and the claim will be dealt with by the insurers. There is no reason to prevent you from pursuing that claim against your employer, nor should you be prejudiced in terms of your employment by doing so. If you think you have a claim, I'd urge you to act now and contact me or a member of my team to find out how we can help you.